Ready? Start. The present criminal appeal arises out of the judgment and order dated 26/6/2025 passed by the High Court of Uttarakhand at Nainital in Criminal Revision Number 201 of 2025, whereby the High Court partly allowed the revision preferred by the appellant wife and enhanced the maintenance awarded by the family court from rupees 8,000 per month to rupees 15,000 per month, payable from the date of the application, that is 18/9/2024, full stop, para. The appellant wife and the respondent husband were married on 7/5/2023 at New Delhi in accordance with Hindu rites and customs, full stop. Following the marriage, the appellant resided at the matrimonial home along with the respondent and his family members, full stop. The record indicates that the relationship between the parties did not remain cordial and, according to the appellant, she was subjected to neglect and acts of physical as well as mental harassment during her stay in the matrimonial home, full stop, para. Within a year of their marriage, the appellant was forced to leave the matrimonial home and return to her parental residence, full stop. Since then, she has been residing separately and is stated to have no independent source of income for her sustenance, full stop, para. In these circumstances, the appellant instituted proceedings under Section 144 of the Bharatiya Nagrik Suraksha Sanhita, 2023, in bracket hereinafter BNSS, on 18/9/2024 before the competent court at Tanakpur, district, Champawat, seeking maintenance quantified at rupees 50,000 per month, full stop. Upon establishment of the family court at Champawat, the proceedings stood transferred and were registered as miscellaneous criminal case number 54 of 2024, full stop. Despite service of notice, the respondent did not enter appearance and the matter proceeded ex parte, full stop, para. The family court, by judgment dated 25/2/2025, awarded maintenance of rupees 8,000 per month to the appellant, taking into account the respondent's salary structure and the deductions reflected therein, full stop. Aggrieved by the quantum so fixed, appellant preferred criminal revision number 201 of 2025 before the High Court of Uttarakhand, full stop. The High Court, void the impugned judgment dated 26/6/2025, partly allowed the revision and enhanced the maintenance to rupees 15,000 per month, maintaining the date of commencement as 18/9/2024, full stop. Still dissatisfied, the appellant has approached this court by way of the present appeal, full stop, para. Learned counsel for the appellant submits that the amount of rupees 15,000 per month is grossly inadequate and does not reflect the true earnings of the respondent, full stop. It is urged that the respondent is in salaried employment and is earning a substantial monthly income, comma, which has not been correctly appreciated by the courts below, full stop. It is further contended that the appellant has no independent source of income and is wholly dependent upon maintenance as claimed, full stop para. It is submitted that both the family court and the high court have placed undue reliance on deductions reflected in the respondent's salary, comma, particularly those arising out of loan repayments and financial commitments, full stop. According to the appellant, comma, such deductions are largely voluntary in nature and relate to acquisition of assets and, comma, therefore, comma, cannot be permitted to dilute the respondent's primary obligation to maintain his wife, full stop. It is also contended that the respondent possesses sufficient means and that the maintenance awarded constitutes only a small fraction of his income, comma, thereby rendering it wholly disproportionate, full stop.